Hello, happy Tuesday. It is the last day of February, which is very hard to believe. I got tired of looking at myself in my office, so I came out here to get a little bit of natural light in beautiful downtown Willoughby. Today I wanted to talk a little bit about homes and the probate process because I've been having a lot of difficulties with this lately. Well, I haven't. It's a good problem for me, but my clients have, which is not good. And really, there's a lot of things that can be done to make sure that your house gets to your loved ones after you pass away, whether that means selling it or somebody living there. And a lot of problems and unnecessary expenses that happen if you haven't done that. So basically, under Ohio law, the simplest thing to do is to have a will and to name somebody as your executor. Because if you don't have an executor, there's a lot of requirements as to how to sell a house, which can lead to literally thousands of dollars in attorney fees and fights. So if you don't have a will, then you have to have all the heirs sign off on the sale of the house, and the house has to sell for 80% of what it's been appraised at, which can sometimes be a problem and sometimes not what is actually best for everybody or what anybody wants to do. For example, sometimes one of the heirs wants to keep the house, but they want to not pay 80% of it. So if you have a will, in my wills, we give the executor the power to sell the house for whatever they think is appropriate. And then they don't have to have all the heirs sign off on it. And that's the other thing. Sometimes not everybody's getting along. So, if there's one holdout, you have to do a very expensive and timely, basically a lawsuit in the court to get the probate judge to authorize the sale. The other thing you could do to totally avoid probate altogether, and I do in a lot of my estate planning, is what's called a transfer on death affidavit. And that, of course, depends on family situations and how many people are inheriting. But essentially, you can file something with the county recorder that says, when I die, I automatically want my house to be owned by my 3 kids, or 4 kids, or 2 kids, or one of my kids, or whatever you want to do. But that actually avoids probate altogether. Then when somebody dies, when you die, they just have to go to the recorder with a copy of the death certificate and basically fill out a form. So that is really the easiest way, but in every situation, it's not always the best for a lot of reasons. So all these things are things that I discuss with my clients, but the selling or moving a home after a loved one dies can be one of the most difficult parts of a probate. So that's one of the things I really dive into in my estate planning. And beyond that, when there's still a mortgage, that's even harder because, okay, now we got a mortgage. The estate's got to go on for 6 months at a minimum. And now I'm asking one of my kids basically to pay my mortgage for me after I die so the house doesn't go into foreclosure. So when we sit down and talk about estate planning, houses, and what we're going to do with our house is one of the most important things. For most of us, our house is one of our biggest assets. So I hope everybody's having a good week, and as we head into March, hopefully we get some warmer weather here soon. Bye.